Hi, I'm Richard Nix. I'm here with my two partners, Judy Burgeon and Brandon Long. We're here today to talk about employee benefits, and specifically, we want to talk about retirement plans and the impact that the CARES Act, which was passed this last Friday, has on the retirement plans. We know most of our clients have 401k plans and are going to be dramatically impacted by it, and specifically, the participants are going to be asking a lot of questions regarding that. Before we get started, I want to address two things that our firm has done. We know that clients are dealing with a multitude of issues because of the coronavirus. And as a result, we've implemented two what we think are extremely important and helpful items for our clients and friends. The first is we've adopted a COVID-19 resource center. You can find that on our website. And what we've done is we've taken all of our webinars that we're doing with regard to all the three stimulus packages. We're putting it under one site so that it'll be an easy resource. We are also pushing out a lot of alerts. That's the best way we can get to our clients as things evolve. We're all drinking out of a fire hose right now, and it's imperative that we get the information to you as quickly as we can, and those alerts are how we do that. To that end, a quick commercial. If you're not signed up for our alerts, I would encourage you to do that because, as I said, that's the quickest way we can get the information to you. But there's also articles and other commentaries under that, and we're constantly updating that. So as you get a free minute and you have questions, that's a great source for you to go to and look, and hopefully it'll be a great starting point to answer the question that you have with regard to these difficult times. The other thing we've done is we've set up a COVID-19 quick response team. We did this back in the Lehman Brothers and financial crisis in 2007, 2008. The reason we did it is we knew that our clients had a number of questions in a wide variety of areas. We wanted them to be able to come in, understand who they could contact, immediately get to the right person, because we know the time's limited and you need the right answer and you need it quickly. So I think if you get on our website, you can find both of those items. I think it will be extremely helpful, and from that standpoint, we'll give you a running start to hopefully answer some of the questions that are coming at you fast and furious. But today we're here, as I said, to talk about employee benefits and retirement plans. And we're fortunate to have two experts in this area, and I'll start with Brandon. Brandon, again, most of our clients have 401k plans, and a lot of them have participants who now, from a financial setting, et cetera, want to access their accounts and are asking a lot of questions. What options do they have, and does the CARES Act expand that?
So they have the options that they've always had, and talking about employees and participants in plans. They have, a lot of plans have a hardship provision that allows employees to take a hardship distribution from their 401k account if they meet certain specified hardships. Mm-hmm. Like, for example, one of the hardship events that you're allowed to take a distribution related to is to prevent the foreclosure on your home, but you've unfortunately got to fit in very specific buckets for expenses for medical care. I mentioned prevent foreclosure or eviction from your home. Mm-hmm. But beyond that, you can't take a hardship under the rules that have existed up until now. A lot of plans, though, do have a plan loan provision, and generally you can take a plan loan for any reason. Most plans allow you to take it for any reason. Those provisions have not changed. The CARES Act, which was passed on Friday, expanded the distribution options that are available to certain participants and the loan options available to certain participants. And I say certain participants because the CARES Act does not mean that every employee that we have can take a new CARES Act distribution. It basically says, and I'm looking at it right here, we just got it on Friday afternoon, and I was telling you right before we started, this CARES Act is 883 PDF.
A light reading.
Just light reading. But basically, any individual who has adverse financial consequences as a result of being quarantined, furloughed, laid off, having work hours reduced, unable to work due to lack of child care, closing or reducing hours of a business owned or operated by the individual due to the disease. So anybody that fits into that very specific bucket, and if you want to, by the way, if you want to look and see those specific categories, we also have on our COVID-19 page, we published an article that lists those out specifically. If someone fits into one of those buckets and they have, for example, adverse financial consequences as a result of having their work hours reduced, they can take a coronavirus-related distribution up to $100,000 from their account. And there's some huge tax advantages related to this that typically do not exist. For example, there is a rule that says if you're under the age of 59 and a half, you have to pay a 10% excise tax on top of normal income tax withholding. For this coronavirus-related distribution that's up to $100,000, it's waived. An employee can also elect to, typically the normal withholding is 20% in addition to the 10% excise tax. The kind of standard withholding amount, I think, is 10%, and as it relates to this coronavirus-related distribution. But employees can elect that to be zero. And so there's some other things I know Judy's going to mention probably, or we'll mention here in a minute, other benefits related to that. But the CARES Act provides for these coronavirus-related distributions, and it's a pretty awesome feature that has not existed up until now. Similarly, there's a new provision that allows employees to take expanded loans from their 401k account, or greater loans than they've been able to take in the past, kind of at a higher limit. But those are generally at an overview level, kind of what the CARES Act provides as it relates to 401k distributions and loans.
So who qualifies for these? 401k?
So as Brandon mentioned, it's going to be if the participant's spouse or dependents are diagnosed with coronavirus disease or the underlying virus, and anyone who experiences, an adverse financial consequence because of it. One thing that I would add about the tax benefits also about the distribution is that participants have the opportunity to recognize that income over a period of 3 years. Normally, when we take an in-service distribution, we're going to be reporting that income in the year that we receive it. The CARES Act allows us to spread that tax consequence out over 3 years. So if I took a $30,000 distribution, I could recognize $10,000 a year for 3 years instead of that chunk all at once.
So does every 401k plan have to offer this, or is this an optional?
It looks like it's optional. It looks like it's an option. Right. So the employer sponsor has the option to turn it on or to not turn it on.
So if our clients want to do this, it's not just sit back. Two things. One, they need to make a conscious decision to either do it or not do it. If they're going to do it, they need to get in front of the employees quickly so they understand those options are available.
That's true, but one step before that is they need to get with their record keeper and the TPA of the plan to make sure that their TPA and record keeper has the administrative capability. A lot of times like this law is passed on Friday. Nobody knew exactly what was going to happen.
Great point.
And then the record keeper and TPA is trying to figure out administratively, how do we do it? I know we saw Friday afternoon. I read something from Fidelity, Milliman, and read something from Principal and Prudential. And all the record keepers, those are the ones that I saw things from. They're all over this.
They scramble.
And they're trying to figure out how to turn this on as quickly as possible.
Yeah, they're really trying to get relief to those participants. And the other thing is they're going to allow participants to self-certify whether they fall into this category for either the distribution or the loan. So that's something else that the record keeper will sort of have to turn on.
The other thing that's really cool about, if there is anything cool in benefits, the one thing that's really cool about this coronavirus-related distribution is people have the ability to repay it back into the plan. Typically, Richard, when you take a hardship distribution, kind of the standard categories that I mentioned at the beginning, once the money is out of the plan, they're going to get hit with an excise tax, which is not going to apply here. And you can't put the money back into the plan. With a coronavirus-related distribution, you're allowed to repay the money into the plan when you're able to get back on your feet. So it's a really nice.
Is there timing on that?
It's in the 3.
I think it's the 3-year window.
Okay.
3 years.
Okay.
Yeah.
Well, and obviously, if you do want to change, you got to coordinate with your record keeper, but you also need to amend the plan.
That's right.
To accommodate that.
And there's a generous time period to do that. It's going to be probably the end of 2022 for most calendar year plans, 2024 for governmental plans.
So from a practical standpoint, just putting the steps in place, check with your record keeper and make sure if you want to do it, whether you can administratively. Secondly, and one of the things that we continue to talk to our clients about, communication. If we leave it up to our employees to read the information from the Wall Street Journal or from from a local newspaper or listen to it, it's going to be wrong. They need to hear from you. They don't have access to the resources that you do as far as that. So they need to hear so that they know.
And tell them how to do it.
Right.
Reach out and say, hey, Richard, the Congress passed, the president signed a new law on Friday. Our record keeper is made this feature. We turned this feature on with our record keeper. If you fit into these categories, if you have the disease, if your spouse has the disease, if your dependent does, if you are financially impacted because your hours have been reduced,
Great point.
Then here's the phone number and the website you reach out to if you want to take one of these distributions. And by the way, there's some additional tax advantages that we'll communicate to you later. And then the plan amendment can be done later.
Right.
Right. That would be the third. But, so many times when you make an amendment to the plan, we're used to the timing of, well, you really don't need to get in front of, legally, you don't need to get in front of your employees with this information till later on. This is one of those that we're encouraging them to get in front of, not necessarily legally, but practically as soon as they possibly can.
Absolutely.
Now let's talk a little bit about loans. I know we've mentioned distributions and loans. How were loans impacted? And obviously, if the plan doesn't allow for loans, I assume it doesn't impact them, but talk a little bit about that, Judy.
Right. So if our plan already allows for loans, the CARES Act increases the maximum amount that participants can withdraw. So normally participants can withdraw the lesser of 50% of their vested balance or $50,000. The CARES Act doubles those amounts. So now we can potentially withdraw 100% of our vested balance or up to $100,000.
One kind of tie into that,
Absolutely.
Judy's 100% right. If you don't currently offer a plan loan feature in your 401k plan, you could always turn it on. You could turn it on now.
Mm-hmm.
And I think you could probably turn it on and only offer this kind of a loan if you wanted to.
Sure.
And the same people that qualify for the coronavirus distribution qualify for these new loans. And so it's this only specific individuals qualify. The other thing that concerns me a little bit about it is that the CARES Act on Friday, not to be too into the weeds too much, but it amended exactly like Judy said. It basically doubled the limits under the Internal Revenue Code. But on ERISA, you're still required to keep as adequate security 50% of the vested balance. And so my question, the one thing that I'm not clear of as I sit here right now, okay, this says I can allow people to take a loan up to $100,000. Well, what if they only have $110,000 in their account? Can they borrow can they borrow $100,000 and it's not secured, at 50% of their balance like the normal rule? So I think we need more clarity on that point. But that's a question I have.
I think they're going to flesh that out in the DOL regulations. I know that the Act gave the DOL, the capacity to do that, to fill out some of the ERISA provisions.
It seems like if someone has a $200,000 balance, it's not going to be an issue because they'll 50% of their balance is $100,000. But I think we need more details on that piece ultimately.
It is amazing in a world, and ERISA is one of those worlds where things typically change very seldomly, and if they do, you can see it coming from a mile away. We are truly drinking from a fire hose, and I think everyone, including the Department of Labor and the Internal Revenue Service, are kind of making it up as they go. Hopefully, we'll get through this time period quickly and then get back to whatever normal is.
Richard, just 3 weeks ago, before the end of the world, I feel like we're talking to clients about the Secures Act, and it was passed in December 20th, and effective January 1, 10 days later. And I was complaining and whining about how quickly it was effective. 10 days later, the CARES Act was passed Friday. It's effective right now. It's an immediate effective date. So back to the record keepers, the details of this that we're all trying to figure out, it's because everybody's scrambling to try to help these, employees and participants get the money they need to get them through this financial crisis. But there will be more details, and I bet it will come out very quickly. I bet we will have things this week to push out to our clients, or certainly the week after.
Is obviously, again, back to what Judy had referenced before, if you don't have loans or if you're making any adjustments to that, you need to check with your record keeper to make sure that you could turn it on, and also check with the record keeper to make sure that if we're going from 50 to 100 and some of these other adjustments, that they're able to accommodate that. If you already had a loan outstanding, is there any problem with then potentially go back to the plan and asking for more money along those lines, or is that all?
I don't think it speaks to that, but right. I don't think there's any problem. I think as long as you stay within these limits, my instincts tell me that as long as we stay in the limits that of this coronavirus-related distribution, even if you already had a loan outstanding, now your plan might already say that you only get one loan.
So you may need to amend
adjust
that.
your plan loan or your loan program. But I think all of those things we can work around. And it's kind of like we've talked about with other things. It's like if you want to help your employees and you want to turn this on, where there's a will, there's a way with these provisions. We just need to kind of look at your document and your loan program to make sure that they all line up.
Obviously, the objective of the CARES Act, and as it relates to loans and distributions, we're trying to make it as available to the participant to handle the economic crisis that they're in. So, not to get down on the government. Sometimes the government kind of puts handcuffs on us and do it. I think they're giving us as much discretion as we can. We need to make sure administratively we can do it, and we still stay within the confines of the CARES Act. We've got a lot of leeway, so we're encouraging our clients to be proactive in making a decision. They can make their decision on which way to go, but to the extent the decision's made, then moving forward with regard to that.
One other thing on the loans, and we might have already mentioned this, you can delay the repayments for a year after you take it. So if someone takes a coronavirus-related loan that we've just been talking about, the first payment, typically, like if I took a normal plan loan today, I'm going to start having loan repayments coming out of my paycheck, at the next paycheck or certainly the next after pretty quickly. They allow you to defer repayments by up to a year, I think. Isn't that right, Judy? And so that's also unheard of. That's never in the time I've been doing this, I've seen anything like it. So they're providing lots of flexibility to people get money, and then in terms of when they have to repay it.
If your plan allows for both loans and distributions, is there one that you have to exhaust before the other, or can you go with either or both?
Usually you can go with either or. There's not necessarily an ordering rule. I mean, always check your plan document just in case you do have a requirement. But I think we got rid of those requirements.
I think we did.
Just recently.
I think you're right. I think the only caveat is back to the adequate security. So if you take a loan from a plan, the plan typically is required by ERISA on the ERISA side for there to be for that loan to be adequately secured by at least 50% of your balance. And so if you take a distribution and you only have $10,000 left, you're not going to be able to borrow $50,000. So and again, we need more clarity on this security piece, I think.
Right.
So let's talk a little bit about the employers. Obviously, a number of employers have been economically impacted by the crisis and are contemplating either cutting back their match or eliminating it. What do they need to be considering with regard to that?
The first thing they need to think about is whether or not they have a safe harbor plan. If you have a safe harbor plan, there are only certain instances in which you can suspend or reduce the match. And what you need to do is first check your safe harbor notice to see if there is language within it that says that you can reduce or suspend the match. If you have that language, you can. If you don't have that language, then you have to have be operating at an economic loss to be able to reduce or suspend that match. So one of those two you need to meet. If you meet one of those two, then we need to provide a supplemental notice to our employees, and that needs to be provided at least 30 days before the reduction or suspension becomes effective.
Okay. Communication-wise.
So safe harbor Judy's 100% right. If you have a safe harbor plan, you have to see if you fit in one of those two categories that she mentioned. Number one, your notice has language telling participants that you've already sent out earlier this year or at the end of last year that you have the right to reduce the match or the non-elective contribution, I think. Or two is the economic loss. But beyond safe harbor, if you just have a normal plan that has a discretionary match or a discretionary employer contribution, you probably have the right, you have the ability to exercise your discretion and just not make an employer contribution. So I think you kind of like we talked about just a minute ago on the other stuff, you just need to check your plan and see what it says.
Obviously, a number of employers are being forced to either furlough or terminate a number of their employees with the idea, hopefully, at some point in the relatively near future, of rehiring, et cetera. Any consequences to that, Brandon?
Yeah, there's the thing that people need to think about that a lot of people will miss, and Judy and I, we spend a lot of time fixing things that people stub their toe on, and this is one of these things that people can stub their toe on, and that is if you terminate more than 20% of your workforce, and there's some Wizard of Oz math that goes behind how you calculate whether you've terminated 20% of your workforce, so don't try to do it by yourself. But if you terminate 20% of your workforce, there's a presumption that you've had a partial plan termination. And okay, who cares? What does that mean? That means you've got to vest everyone that's terminated as a result of that, or I think it's actually within the same plan year. So, meaning if you terminate 20% of your workforce as a result of the coronavirus downturn, and Brandon Long had a $10,000 balance and only $5,000 of it was vested, you're supposed to vest Brandon and the other $5,000 if you have a partial plan termination.
Mm-hmm.
If you miss this, what happens is Brandon's only going to get a distribution of his $5,000, and then you would forfeit the other $5,000 incorrectly, and that's something you're going to have to fix later. So the big message as it relates to our employers is if you're going to have a layoff or a termination of a big chunk or a division of your employees, you need to be thinking about a partial plan termination.
Yeah, just make sure it's on the radar. It'll also be on your auditor's radar most likely as well. So just be asking those questions about it. Ask your attorneys, ask your auditors if this is something you need to worry about.
In the great scheme of things, it's probably not going to drive whether or not people running a business are able. They just need to be aware of it.
Right.
So that, our whole objective in this is that you make an informed decision and that there aren't any surprises. You may not like the answers, but you certainly want to get them. And that's what we're trying to do here. And that's a surprise that a number of people wouldn't be aware of.
Well, and it's one of those things, too, that you may screw it up and not even realize you've screwed it up until next year when your auditor comes in and tells you screwed it up. And so it's like, just think about it now, and so that you don't have a mistake you have to fix later.
Good point. One issue that has been near and dear to a lot of the participants, we've had a tremendous market investment-wise for a number of years, but a number of their participant accounts have been impacted by the volatility in the market. Most of our 401k plan clients that are sponsoring 401k have investment committees, et cetera. Do they need to be doing anything proactively with regard to the investment committees, and what would you recommend regarding that?
The advice for committees is very similar, I think, to what we tell our participants about their own investment portfolio. And that is, let's not overreact to a market downturn. It's easy to say, it's harder to do. But we tell individuals this is not the time to lock in losses and to cash out. I would say the same thing to our committees, our employers that are overseeing or that are the fiduciaries of their committees. It's if you have been prudent monitoring the investment options, your investment menu and your stable value fund and your target date fund and the other options you have, if you've been prudent up until now, you're probably just fine with what you have. But ERISA doesn't require us to take any certain action at all in response to the coronavirus or any other emergency. But what it does require is that we're aware of the fact that the coronavirus exists, and we've taken that into account in evaluating our choices for our plan participants. And so, okay, what does that mean? It means have a special meeting right now with your investment committee, even if you do it over the telephone, or Zoom or whatever, technology you're using, and just acknowledge and put in your minutes that you're aware of the fact that we have a public health emergency, that we have an oil emergency, that the market is doing funky things right now. And despite all of that, we still feel comfortable and good with the options we've given our participants, including our stable value fund and our target date fund. And as to the stable value fund in particular, if you look at the 2008, the last time we had a significant market downturn, that's where participants and their lawyers will sometimes throw stones at fiduciaries and file lawsuits because people think their money's safe when it's not. It's never completely safe. You might look at the investment, your assets in your plan lineup, and look at your stable value fund. Look at other categories of investments where people have parked a whole bunch of money, like the target date fund or the default fund that you have. And you might talk about those first and reflect that discussion in your minutes first, so that you're you're acknowledging the end of the world crisis we have. I'm being sarcastic, but we're acknowledging the emergency we have. You're talking about the categories in your plan lineup that have the most amount of money, and you're asking questions. And ask questions, get your advisor. You pay a co-fiduciary, an advisor, to sit on these committees with you or help you make investment decisions. Let them share the fiduciary responsibility with you, but just have some minutes that reflect the fact that you acknowledge what's going on in the world, you still feel good about what you have, and you continuing with what you have and hoping for the best for your participants. To the extent you feel it's important to push additional communications to your participants about, all sorts of maybe general investment education about, the market will come back or whatever you want to, work with your investment consultant to do that. But I think it's just important for people to document kind of where we are. And then specifically for our clients that have company stock funds in their plan accounts, it's very important that you do what I just mentioned as if you have a company stock fund. So make sure you are at least acknowledging the crisis and its impact on your stock, and make a decision as it relates to the retention or changing the structure of what you have. But just make sure you have some. Let's leave a nice little breadcrumb trail
There we
to
go.
show that we thought about it and we feel good about where we are.
I mean, ERISA doesn't require us to be right. What it requires us to do is be prudent. And the way you're prudent is you stay on top of things. And this was obviously a dramatic event. So one of the things I would think that if I were a Department of Labor agent, I would want to know, so what did you do? You're on the committee. What did you do? And I think the best thing you can do, as Brandon suggested, is get together. And we're about to be at the end of the first quarter, figure out what, where, and how. And even if you decide not to do anything, which is probably where most people are going to be, you've got a record, you've got minutes that reflect that you did in fact meet. You've got confirmation from your folks. And this is another time where an investment policy statement that specifically defines what you're doing, how you're doing it, and the others are instrumental. And if you don't have one of those, would strongly encourage you at the appropriate time to have that as well.
Just a couple other follow-up, if you don't mind, Richard, related to the investments.
Mm-hmm.
So a couple of questions that have popped up this week. Here's the scenario. We're in the middle of moving our plan from, and I'm just making this up, Fidelity to Vanguard, or pick it the other way around, Vanguard to Fidelity. And we're scheduled to have a blackout period starting next week where people are not going to be able to mess with their investments. Should we go ahead and move forward? If the answer is our blackout period is next week, maybe not. Maybe you think about, and I'm not giving you advice not to do that, but you need to think about whether this is the time to have a blackout period. If your blackout period is scheduled a month from now or 60 days from now, I would keep doing exactly what you plan to do up until now. So just, again, let's not overreact to this, but also be aware of the fact, the whole idea behind a blackout period is participants can't make investment choices because their money is being moved from one record keeper to the other. I don't think this is the time for people to be pulled out of the market and be deprived of their own investment choices. And similarly, a lot of our clients will do a reset of their default fund. If Richard Nix makes a deferral into the McAfee and Taft plan, Richard puts in $1,000 and he doesn't tell us where he wants the money to go. His money goes into our target date fund, right? Well, some of our clients are doing a reset of their investments where they've sent out notices to participants saying, hey, Richard, I know you've made purposeful choices to be invested in A, B, and C, but we are giving you a notice that telling you we're taking you out of that and we're putting you into the default fund unless you go in and affirmatively select to stay in what you have. Again, I wouldn't do that right now. The market is too volatile.
Could be some exposure
so
to that.
Make sure your participants are the ones making decisions about their own investments and not you.
Mm-hmm.
Well, and to the extent anything is on automatic pilot, I think you take a step back and just look at it and evaluate, because the new normal has completely changed over the last several weeks, and we just need to be conscious, always understanding that for most people, most of the participants are going to retire when they want to and how they want to based on their retirement account. And so the 401k plan is extremely important to them. And whether you have a legal obligation or not, I think practically speaking, getting in front of the clients with information, with assurances that you're on top of this and that you're meeting with and all the things that are going on with their account, I think would be well received. And in the long run, maybe the right thing to do with regard to that. So to that end, any other questions or any other thoughts with regard to the CARES Act that you want to bring up?
I have just two things I might add with regards to required minimum distributions. The CARES Act does allow us to suspend any of those that were otherwise due in 2020. And the other thing, a little bit off topic, is for defined benefit plans, single employer defined benefit plans. There's a little bit of relief for your funding payments. They can be pushed out to January of 2021. You will still have to pay the interest on those.
Yeah, those. And again, all of this is incredibly fluid. We intend to continue to update our Coronavirus Resource Center with regard to new information and webinars that we're doing. Brandon, I know that at our last practice group meeting for employee benefits, we discussed the idea of maybe having a conference call with clients. You want to go into that a little bit,
Sure.
what's contemplated?
Yeah, I think we're talking about having maybe a once a week, what we're calling kind of a town hall kind of format where people can call in. We'll give them an update on what we learned, because I think there will be a lot of moving pieces as we move forward on kind of filling in the details on some of the things we talked about. And we'll also give people the ability to email us questions and ask questions that we'll try to answer on these telephone calls. And so that's really what we're planning to do, maybe a once a week at a certain time, at least for a period of time till we get through this craziness.
Well, and that's a good segue. We understand that this is a difficult time. McAfee Taft's going through it as well. And we're having to deal with it from an employer perspective for our employees, giving them assurances that, we're on top of this and we're going to get through this collectively and together. We know you're having to do the same thing. You're filling the questions. And so our commitment to you is that we'll be your eyes and ears, and that we will stay on the cutting edge as the laws come out, as regulations come out, as any policy changes, et cetera. Our objective is to push this information to you as quickly as we can. The best way we can do that, again, is through alerts. If you haven't signed up, please do so. But also, we'll continue to do these webinars. We'll do whatever we have to in order to get the information to you, so that you can make informed decisions and timely decisions. And we know how important that is. So with that, I'd like to thank Brandon and Judy for their time and their great advice. And we also want to thank you for joining us. In the meantime, we'll be in touch with you. But in between now and then, stay safe.